Morning here with Pat McGuigan, and talking first this morning, Pat, about a potentially very important ruling by a Virginia judge on what a lot of people here call Obamacare, but the national health care measure that was passed by Congress. A portion of the ruling, the judge ruled that a portion of that bill is unconstitutional. Is that right?
Right. To quote directly, he said it was illegal, unconstitutional to, quote, compel an individual involuntarily to enter the stream of commerce, close quote. Those are nice legal kinds of words, and what they mean is to force somebody to do something that's traditionally been voluntary, and that is how to seek health care, whether or not to seek health care, in what manner to seek health care, or even whether or not to seek it at all, is a private right. Now, there's other criticisms of the federal legislation that critics call Obamacare, but that's the one he agreed with. He actually left the rest of the law in place, but an argument is made on both sides of the spectrum that at least conceivably that is the linchpin, because it creates the financing pool that arguably, and it is arguable, that arguably would be sufficient to finance it. So at the end of the day, Judge Henry Hudson, an important decision. Now there should be noted there's been two other lower court, federal court cases, one in Michigan and another one in Virginia that went the other way, that said that the law was fine. It was a legitimate exercise of the question here is the Commerce Clause under the U.S. Constitution. So two cases have said it's fine, one has said it's not. Now, the Florida case is teed up pretty well for critics of the new federal legislation. So that will be very significant, and there's already 20 states involved with it. And if I had to guess, I'd say, although you might see the new Attorney General for Oklahoma, Scott Pruitt, you might see him join the next stage as a amicus brief of the Virginia case. But I think the odds are pretty good that Oklahoma will seek, and I don't have any special knowledge on this, it's just speculation, but I think Oklahoma might join the Florida case. Ken Cuccinelli, I believe is how it's pronounced, the Attorney General of the Commonwealth of Virginia, came to Oklahoma to support Pruitt back in October during the election campaign. And Cuccinelli handled reporters, including myself, very well, answered a lot of in-depth questions about law. He thinks there's other problems with the federal legislation, but he did say that the mandate was absolutely at the core of the arguments against it. So what does this mean for Oklahoma? It could mean a lot of things. First of all, we might, as a state, intervene in the case, which Attorney General Drew Edmondson, who still serves until January 10th, has declined to do. Right. But in policy terms, the projections are that Medicaid will, within 10 years in Oklahoma, cost as much as the Department of Corrections, something you and I have discussed previously, where there's a constant need for more money. Right. So that's a pretty scary projection. It's a scary projection no matter what, but it's especially a high projection under the provisions of the federal legislation. Now, in Oklahoma, the one thing to say for our state officials, Democrats and Republicans, is it's not like they've ignored the lower end of the health insurance pool. Insure Oklahoma, OEPIC, and other programs have been created using state resources, including the tobacco dollars, to create access to health insurance and a health care pool for lower income Oklahomans. The speculation now is that maybe those will get even more invigorated so that the state can design its own plan, if that's allowed, as the federal legislation is further developed and not repealed. Now, if it's repealed, then we kind of go back to the status quo, except there have been several months of changes and tinkering made now in the insurance system. So this is going to be a big issue. An
issue with a lot of layers.
A lot of layers, that's a good way to put it.
Speaking of courts, of course, our Supreme Court here in Oklahoma has a vacancy, and there's been quite a bit of speculation as to whether the outgoing governor or the incoming governor is going to be the one to fill that spot. What do you know about this?
Yeah, Governor Henry and Governor-elect Fallin have not argued about this publicly, but there is a discussion going on, I guess you could say, maybe an argument among surrogates. And the surrogates are on one side making the argument that things should wait for Fallin. An argument's being made by Fred Morgan, a former state representative who now runs the state chamber. And he's been supported, at least in part, in this argument by Chris Steele and Senator Bingman, Brian Bingman. Now, on the other side, you have Alan Smallwood, who runs the existing Judicial Commission, to some extent Drew Edmondson on pieces of this. Now, here's to summarize the issue. State question 752 enlarged the Judicial Commission and the job of the from 13 members to 15 members, and made a change saying that you could not be a relative of a lawyer and serve on the Judicial Commission. What that meant is that right away 3 members of the commission stepped down.
Right.
Then you have another member who is an elected school board official. So the 13-member commission now, if the critics are right and that person should step aside, you're now down to 9.
And then there's one more, too.
And then there's one more who, it's a little more arguable, who's, on the board of directors of the Oklahoma School of Science and Math. So then you're down to 8. So in one change, you're below a quorum of the newly constituted 15-member. Now, Smallwood and Morgan have been carrying on this discussion, and again, I think you could make a pretty strong case that they're surrogates for the 2 principals. The earliest they can probably get done with the existing commission of pooling 3 recommendations for the governor, Henry, would be sometime just before December 31st.
Wow.
And Fallin takes office on January 10th. So this is a pretty good little argument because, in part because Brad Henry, it takes Oklahoma governors under our populist system, it takes you a couple of terms to really have an impact on boards and commissions, let alone on the courts. Well, he's appointed 5 of the 9 members of the state Supreme Court, and some people are saying that's enough, but he is the governor until noon on the day that they all take the oath. So to say that this is going to be interesting is to understate the case. Because for the new commission to become fully operational, for example, you have to wait until Steele and Bingman are officially, not just the Speaker-elect and the President Pro Tem-elect, but the official election takes place in early January. So there's going to be a window. Let's say things play out that way. The governor gets 3 names sometime around December 31st. Then in early January, the House and Senate leadership is formally elected. You're going to have a window of 5 or 6 days where arguably the 15-member commission minus 3,
right,
plus the 2 back in, might be able to make a decision, and it could get, the argument could become a little more public, conceivably, between Governor Henry and Governor-elect Fallin. Okay, there it is, the Reader's Digest version.
And throw into the mix that Jerry Askins could be one of those candidates.
Oh, very good
interesting.
point, because there was a very credible, respectable pool of several names, and what they do is they submit 3, and one of those names who did apply is Jerry Askins, who actually has experience as a lower court judge who would understand trial issues that would be on appeal to the state Supreme Court. So, wow.
Yeah.
Could be fun.
You can read more about this at CapitolBeatOK.com. Thanks, Pat, for being with us. Have a good day.